Hello and welcome back. Now in this lecture we're starting to look at agency law. Now we all deal with agents sort of every day of our life. We might get a travel agent to book a holiday for us, or an estate agent to deal with the sale of our house for us. And in each case we're asking another person to negotiate a contract which eventually they won't be a party to. Now, one of the more common occurrences of agency law in the business world is for a company director or a business partner who binds the partnership or the company in a particular contract. So let's have a look at the example of, say, a company director. Now, he may negotiate with a third party in a contract which eventually he hopes will be entered into between the third party and the company. But the company, although it is a legal personality with the capacity to enter into a contract, isn't able to negotiate a contract in its own behalf. It can't discuss the terms of a contract. It does so through the director. So the director is the agent. The company, who will eventually be bound by this contract, is the principal, and the third party is still the third party. Now, in terms of an agency arrangement, you need to be able to understand how agency is created. Now, one point that we would make just before we move on to the details of this is about capacity to contract. I've seen the examiner more than once ask this question. Now, the agent, remember, is not bound by the contract, and therefore he doesn't have to have capacity to enter into the contract. However, the principal, the person who will be bound by the contract, in my previous example, the company, must have full contractual capacity. So, how are we going to create our agency? Well, the easy way is by consent. So maybe I authorise a friend of mine to go to the shop and to buy a wheelbarrow for me. I might say, I want you to buy me a wheelbarrow. I want you to spend no more than £150 on that wheelbarrow, and I want you to get it from B&Q. So I have set out the terms of the agency, and I've given the restrictions, the limits, if you like, of my authority under that agency arrangement. Now, I can create that authority either orally, or I could set out on a piece of paper and detail all the terms. Now, the only time when my agency agreement has to be set out in writing is when I want the agent to enter into a sort of contract that would need to be executed in writing. Now, how does this agency agreement arise? Well, there's various ways. Let's start with agency by estoppel. So agency by estoppel is a posh way, really, of saying that agency arrives because someone is unable to go back on their original words, their original statement. It's an equitable principle. So imagine that the principal gives the third party the impression that they have appointed an agent. So perhaps I tell a supplier of my business that I have authorised my manager to enter into all contracts in connection with stationery. So I've given the third party the impression that it's all right for them to negotiate with my secretary. The third party therefore relies on it and places and accepts an order from my secretary. Now, it's not possible for me to go back on my original word and say, well, actually, I'm not going to honour that contract because my secretary didn't have authority. So again, if we look at this as a picture, we have my secretary, we have the third party, the paper supplier, and we have me, the business person. So I've let this third party believe that it's okay to enter into contracts on my behalf with my secretary, and I've led him to believe that if he does that, I will honour the contract. And I can't go back on that word unless I've told the third party that I will no longer honour any future contracts entered into by my secretary, i.e. I have withdrawn her authority to enter into the contract. And that's quite often how an agency arrangement will arise, because the person who grants the authority, the principal, has forgotten to let various third parties know that he has withdrawn his authority. Let's have a look at this worked example, and this shows you exactly that point. Paul leads Tina to believe that Adam is Paul's agent. So Paul, being the principal, lets Tina believe that Adam is the agent. So we have agent, principal, third party. It's always helpful when they use the right initials, isn't it? So he has created an authority by estoppel. And Tina, therefore, enters into a contract with Adam on that basis, believing that it's actually a contract with Paul. So in this situation, Paul's bound by the contract which Tina enters into on his behalf. And how could this have arisen? Well, as we've already said, it could be where Adam has continued acting even though his authority has been withdrawn. Or it could happen if Adam has been entering into transactions with Tina, and although Paul hasn't actually expressly given Tina the impression that Adam is authorised, he hasn't done anything to correct Tina's assumption. Okay, now that's an important point. Paul has to know that Adam is acting as an agent, who's pretending to be an agent and pretending to have authority in order for Paul to be bound. Okay, another situation when an agency arrangement can arise is agency of necessity. Now, for this to arise, it's a pretty limited situation. It used to be much more common, but with the age of modern communications and so on, it's not as likely. So an agency of necessity arises where there is an emergency and someone else's property is in immediate jeopardy, it's in danger, and they're acting to try and protect that property. Now, in that situation, you can act without authority, and then later on, you can say, well, you were acting as an agent of necessity, therefore you had implied authority there. Now, in order to show this, you need to establish all of these points. First of all, it wasn't possible to contact the principal. Okay, so as I say, less common now in the age of mobile phones and so on. There was a pressing need for action, there was an emergency. You acted in good faith for the right reasons. Your action was reasonable and prudent. And then finally, and this one is generally the nail in the coffin when you're trying to establish necessity, you have to be able to show that there was some prior contractual arrangement between the parties. So for example, imagine that you see some animals in a field, the field's flooded, and you think the animals are in danger. You can't get hold of the principal, so you take some action to rescue those animals from that dangerous situation. You're acting in good faith, your action's reasonable and prudent, but you need some prior contractual arrangement. So if you don't know who the owner is, you've never dealt with the owner, you're not going to be able to establish agency of necessity. On the other hand, if you were perhaps the vet that looked after those animals, then you would have that prior contractual arrangement and you'd be able to claim necessity. And the example there is a case where the defendant was storing the claimant's furniture. And after a while, he decided he needed his space back, not unreasonably, couldn't track the claimant, so he sold the furniture. And the claimant sued him. The defendant said, well, agency of necessity, I had to make some space, so I sold the furniture for you, here's the money. The court said no, there was no emergency here. Therefore, he'd sold the furniture for his own convenience. He therefore couldn't claim that he'd sold the furniture as an agent. The only time you would be justified is if there'd been an emergency and the furniture had to be rescued, for example, from a fire or something like that. Another way we can create agency is what we call agency by ratification. Now, ratification means there was no agency arrangement in the first instance, but subsequent to the contract being entered into, the principal decides that he would like to adopt the contract. So imagine that my friend is out shopping one day and sees a rare painting. She knows that I love this particular painter. She knows that this painting is very rare, so she buys it for me. Now, when she has no authority to buy that painting in my name. However, when she tells me what she's done, I'm so pleased, I want to accept that contract. I therefore ratify it. I adopt the terms of the contract. Now, in order for ratification to be possible, the principal must have existed at the time of the contract. Now, that's not normally a problem if it's an individual, but if you're looking at a company won't be able to ratify the acts of its agent before the company was properly incorporated, and we'll come back to that point later. The principal must have legal capacity to make that contract himself, both at the time of the original contract and at the time of ratification, so legal capacity. The next one, the agent must make it clear that he is acting as an agent. Therefore, the contract isn't supposed to be in his own name. I must ratify within a reasonable time. That sounds reasonable. And I must ratify the entire contract. So imagine that my friend has not bought one painting, but maybe a series of 10 paintings. And I can't afford all 10. I can't pick and choose. I must ratify the whole contract. Now, in order to ratify, how do I do it? Well, I just have to communicate the fact that that's what I want to do. Now, that would probably be by paying the purchase price for the paintings. It could be by express words. It could be that I just phone up the dealer and say, yes, I want to accept this contract. Now, once we've established an agency relationship, there are certain duties and rights that apply to the agent. And they are set out on this table. They do get tested from time to time, so just try and be as familiar with them as you can. So the agent has a duty of accountability. He has to provide full information to his principal, and also he has to account for any profit that he's made as a result of the agency. And the case there illustrates the point, Boston deep sea fishing. In this case, Ansell was dismissed because he accepted commissions from suppliers based on orders that he placed in the name of the company. As an agent, he should have accounted for the profits that he'd made, paid them over to the company. You must avoid a conflict of interest between your own rights and interests and those of your principal. Performance. If you are a paid agent, then you have a contractual obligation to carry out your task. If you're not paid, there is no such obligation. And of course, you can't be forced to do anything illegal. You must be obedient. You must follow the instructions of your principal. But again, only so far as they're lawful and reasonable. Okay. Skill, if you have any skill, or if there was a certain level of skill implied in your appointment as agent, then you must use that skill. You have a duty of personal performance. Now, normally, if we choose an agent to act for us, it's someone we trust, someone who has particular skills that are important to us. Therefore, an agent usually has a duty to carry out his duties personally. Confidence. By confidence, we're talking here about confidentiality. The agent must keep in confidence anything he learns of his principal's affairs. And again, that's not just during the agency relationship, it will apply even after the agency relationship has ended. Now, if the agent has duties, he also has rights. And those rights, there's 3 key rights to think about. Indemnity. So although he has to account for any profits he makes under the contract, he does have a right to be paid any expenses and be indemnified for any losses that he incurs. Now, the interesting point there is if he incurs expenses in the course of carrying out his agency, even if he wasn't legally obliged to incur those expenses, he can still claim them back from the principal. He's entitled to be paid, but he's only entitled to be paid the amount that was agreed. And that's either express agreement or implied agreement. And finally, he has a lien. So if we have an agreement that says he has to be paid, he has the right to hold on to the goods belonging to his principal until he's paid. So we see a lien from time to time in contract law. For instance, if you took your car to a garage and had some repairs carried out, the garage would have a lien over your car until you paid them for the works, i.e. a right to hold on to your car until you'd paid what you owed them. Now I think we'll pause this recording and we'll come back to look at the authority of an agent in a separate lecture.